Good morning to our wonderful listeners and welcome to the number one station, the best engineer in Dominica, Dean. And this morning we're having just a change in the programming insofar as the Ministry of National Security and Legal Affairs is concerned. Normally we meet on a Thursday night, but this program is going to actually clash with an event tonight. So we are actually, we have been spared by Debris Radio an opportunity to have this program in an abbreviated form for 1 hour and to speak to some very important matters, more so as it relates to the protection and care of children and more so vulnerable groups, you want to say. We will look at it from two perspectives, one from a social services standpoint and then from a criminal law standpoint. And that will speak to, of course, to the whole issue of the Sexual Offences Act in itself, where we look at specific sections. What I want to do today is to look at ourselves and to do some introspection and to ask ourselves, including myself, are we doing what we're supposed to do and to protect those who are under our care, to protect those within our communities who are vulnerable, more so children, and to say that the government of Dominica did something very significant. Amongst all the other things the government has done, you see the infrastructural development, etc. But there are some things that are important, but you cannot see them. They are not tangible, but yet important to our development, or social development, so to speak, and the country's and societal civility. And so in 2023, a number of, or a suite, for want of a better word, of family laws were actually enacted, namely the Statute of Children Act, and that act in itself thus wiped away all element of discrimination, especially as it relates to children. No longer is a child characterized as out of wedlock, a bastard, all those things your government has done and set aside. We have the Maintenance of Children Act, and we have also the Children Care and Protection and Care and Adoption Act. So we will place an emphasis on that particular and specific piece of legislation. We're not able to look at every aspect or every section of it, but we look at some important sections that relate to us, our responsibility. And in some cases, a legal mandate is placed on some of us to report incidents of abuse, neglect, whether sexual or family-oriented in terms of neglect or lack of protection, and to report that to the Director of Social Services. And the act that was made reference to created a number of offices, one of those being the Director of Social Services, who has certain legal responsibilities and to ensure that children and other vulnerable groups can be afforded the protection they ought to get when they're not protected by those who are so entrusted so to do. The Maintenance Act, we'll not talk about that. I'm not referencing some of the acts that we have to actually pass. And the Domestic Violence Act, and of course we had some amendment done of the Children Care and Adoption Act in 2023. This morning we have with us two bright, young Dominicans who happen to be ladies. And we have the DPP, Ms. Shema Darampel. She is in studio. And we have, of course, Tisha, Coffee Mistress, Kazimi, and she's out of state. And we had a wonderful meeting last week. And she's so committed to the cause. And instead of allowing somebody else to come on her behalf, she's joining us via Zoom. What we're going to be doing here this morning, what we'll start by doing, is to introduce firstly the Director of Social Services. And what I would like her to do for us this morning, for those of you who are listening, just tell us something about functions, and then we actually go into next, as we graduate into further discussion. Good morning to you.
Good morning. on thank you so much.
Hello. Good morning. What happened there? Good morning. Oh, she has just, or our technician just have me go in there. But let us try to get it back and let us go across. Can you get Schumer? Hello.
Good morning.
Good morning,
Mr. Minister, and good morning to all listeners.
Yes.
I'm Shema Dalrymple, Director of Public Prosecutions. I'm charged with the responsibility of prosecuting sexual offences in the Commonwealth of Dominica. Most of these offences are dealt with in the High Court. We operate under the Sexual Offences Act, Chapter 1036 of the Commonwealth of Dominica, which is very strict. Contrary to what certain individuals may say, the sentencing under that bit of legislation, it is very high. The sentences attached to various offences, and also the obligations placed on guardians, caregivers, parents. It's also very strict, and also criminal sanctions are attached to certain actions by individuals who obstruct, who pervert these matters from being brought to the court.
Okay, let me see. We have Mrs. Coffee, Mrs. Casimir on. Good morning.
Hi, good morning. Can you hear me?
Yes. So I want to start with you. I'm so happy that you're with us, even if you're not in Dominica. Thank you very much for that. Yes.
Thank you very much for the opportunity to speak with the public on an issue that concerns every one of us, really, which is really the protection, safety, and well-being of our children.
Yes. Go ahead.
Before we delve into the specifications of the functions of the Office of Director, as well as the Office of the Department of Social Services, one of the messages I just really want us to emphasize this morning, and I think it's a very, very simple message, is that child protection is not the responsibility of the Department of Social Services alone. It is a national responsibility. The government has its responsibilities. The Department of Social Services has its responsibilities, yes. The police have a responsibility. Schools and teachers have a responsibility. Healthcare professionals have a responsibilities. We have the parents and the families have responsibilities. Churches, our community organizations all have responsibilities, but most importantly, the ordinary citizens have responsibility. We cannot build a social or a protective environment for children if we believe that protecting children is someone else's job. And if we understand this simple message, I think the objective of our meeting here or discussion here this morning would be embraced and understood better by the general public.
Yeah.
I think one of the questions you asked, or one of the things that you wanted me to highlight, is really the mandate of the Director of Social Services.
Okay, before you go, the reason why we wanted to develop a story there, because I intended to have gone to the responsibility and obligation, and because that's, as you know, that is specified in law, in legislation. It places a mandate on people. So it's not like you have a choice, so to speak, but there's a legal requirement prescribed by law under the act I just prescribed. So that's why you wanted to look at Section 12 after Section 8, and then we go into 14. And if we have time, we can look at Section 25, which is very critical, which speaks to emergency orders when a child or a vulnerable person is actually, and that person needs protection, what you can do to move the process and to provide safety for that person. So, yes, I'm happy that you did that, and maybe we can just continue and speak to. So, what I would like you to do is to qualify what you're saying, because it's not like a moral responsibility, so to speak, but it's a legal responsibility. The government has gone past laws and say, if you're a priest, if you're a pastor, if you're a nurse, if you're whatever you are within the community, that you have a legal obligation to report to the Director of Social Services any neglect, abuse, whether it's verbal, whether it's financial, all those are stipulated in law. So, yeah. Mhm.
I'm happy that you brought that out too, because we often find, I mean, sometimes it's ingrained in our culture to believe that for some reason or another, we withhold certain information, we refuse to report, we cast a blind eye to things that we shouldn't. But and we'll go into section 14, which specifies the actual persons that are mandated to report. But you highlighted some of them. But one of the things that I want to highlight also is the failure to report.
Right, yeah.
As prescribed within that act, the failure to do so has legal repercussions.
Yeah.
Okay. And persons can be fined up to $5,000 or 3 months imprisonment for the failure to report.
Okay. What I would like us to do, very good. If you look at your core function quickly under section 8.1, and then we can move into section 12, that speaks to a child is in need of care and protection, and to describe the children in need of care and protection, because the law also stipulates, you know, the threshold, so to speak. So what we can do is to maybe tell us, because you're a big person, you have a lot of powers, and you're a creature of one of the acts that I just make a reference to. Yes.
Right. Right. So you highlighted section 8, but just to mention section 7, which basically established the role of the office of director. It is established within the ministry responsible for social services, and 8 goes on to basically further outline the functions, and in summation highlights that the director is responsible for the overall care and protection of children, and these include, of course, safeguarding the safety of the children, the welfare and the well-being of children. It ensures that reports are assessed and investigated, overseeing the child care services, as well as developing policies and procedures in making arrangements concerning placement for children. It also highlights the importance of protecting the confidentialities of children's record, and of course providing advice on the services and resources required in order to best protect the children. Basically, what is that highlighting? It's highlighting that the responsibility is ingrained in basically assessing, investigating, determining the level of risk, identifying appropriate interventions, and of course supporting families where it is safe to do so, and if not, to take action where necessary for to protect the children. In essence, it highlights that the responsibility is not simply to just take away the child, but to exhort, to explore, to assess, to intervene where appropriate support before a removal is made.
Okay.
So like you highlighted, it's a mammoth task, and it's a responsibility ingrained in law that the director and the Department of Social Services has. Now, in order to execute effectively, of course, it brings me to the point that I made earlier in my introductory statement, the importance of the recognizing our responsibilities as individuals in order to ensure that the functions of the department are followed through well.
Okay, go ahead.
Okay.
Yeah.
So you gave reference to section 12, which basically highlights the persons that are mandated by law to report. Sorry, section 14.
14, yeah. Let's, if it's okay with you, can we look at section 12, some element of it, in a way that the public can understand? So, because there's a threshold, as to when do you report, and
right.
Yes.
Right. Right. So section 12, in essence, basically highlights the need for children in need of care and protection. And it's extremely important because it provides a broad description of circumstances in which the children may require care and protection. And this includes situations such as involving neglect, abuse or risk of abuse. Of course, we have sexual exploitation, exposure to domestic violence, issues of abandonment, inadequate supervision by parents, or inadequate protection. We have certain untreated physical or emotional developmental needs. If all these things are destitution as well. So these are clearly defined circumstances of children requiring care and protection.
Very good.
And this is why child protection cannot be reduced to only a physical or a sexual abuse. A child may require protection because of severe neglect. A child may be living in an environment of domestic violence. A child may be abandoned. A parent may be genuinely be unable to provide a safe care for their children.
Mm-hmm.
And there may be serious emotional, of course, and psychological harm done to the child. So our responsibility is therefore to look at the total circumstances of the child. And the fundamental question should now be, is the child safe, and what must be done to protect his or her welfare and well-being? And that basically forms the nucleus of us going in when we assess and investigate to inform intervention.
Fantastic. Yes, I think also the issue of, so it's very broad, even on the issue of a child who requires medical attention, and then for some reason the child is not being allowed. It could be as a result of the inability of the parents to do that. That also is a concern for you, and the law actually stipulates that, and that child also will be seen as some form of neglect and needs some protection. Okay. Now, yeah, so now we go to the important part, and because I look at it myself, and I like people who are listening now, because it's a societal responsibility, so to speak, the broader community. And you have the household, you have the family, but you're a neighbor, and you're seeing a 12-year-old, a 8-year-old. It can be 16-year-old or 17-year-old, because a child is defined by someone who has not attained the age of majority, like somebody under the age of 18, under the specific act we're talking about. And then so you have a responsibility to report the matter to the social services. So let us, if you, with your own time and your style, you may want to just remind us of our responsibility as per the laws of the country.
Okay. Section 14, and I think you alluded to that earlier on, which speaks specifically to mandatory reporting.
Mm-hmm.
I think it's important to maybe just highlight persons that are mandated to report.
Yeah, that's right.
And I think that's one of the most important provisions that the public needs to understand in section is section 14 as it on mandating report. The Act clearly identifies a wide range of persons with responsibilities for reporting. These include medical practitioners, nurses, hospital administrators, principals, teachers, guidance counselors, child care personnel. We have police officers, members of the clergy, welfare and probation officers, social workers, parents and legal guardians, as well as other persons whose employment or occupation gives them the duty of care towards children. So where such a person knows or has reasonable ground to suspect that a child is in need of care and protection, the matter must be reported immediately to the director or through the channels provided in the Act. And the reports may also be done anonymously, because sometimes persons are afraid for some reason or another. There's a major cultural shift that we need to embrace, really, because sometimes we hear, I didn't want to get involved, or that is a family business, or I heard something but I wasn't sure. somebody else will do the reporting. But where the safety of a child may be at risk, silence can have serious consequences. You do not have to conduct the investigation by yourself. You report the concern so the appropriate authorities can assess it. Without the report, social services can do nothing. Without the report, the police can do nothing. And I think if persons understand that even if it is not their occupation or their role is not clearly defined in law, but it's the responsibility as a citizen, as a human being, to report something which concerns the well-being of a child.
Yeah.
And the law in itself provides protections for persons who make reports in good faith.
Right, that's important.
Including the protections relating to confidentiality and liability. So I think sometimes persons may be afraid of reporting because of the fear of not being protected. But the law in itself provides protection for persons who report in good faith.
Excellent, excellent. Now we're going to come back because someone may want to ask, what kind of protection do you provide? What systems do you have in place in the event there's a report of a child needing to be removed from an environment almost immediately? And what facility do you have in law to move the court in quick time? And what infrastructure do you have in place to have that child in temporary care away from the police of abuse? So maybe you want to think about that a bit, and we'll go across to Miss Darampo. And her role, of course, is more or less to prosecute from a criminal law standpoint. And there's a nexus, of course, between a number of instances. You may get a case of abuse, and when you get it, you realize it's criminal, maybe sexual, in nature. So you have to report it to the police. And so, we should have actually brought in the police, because we also have within the police force people who are trained and within the police force to give effect to that law on the issue of domestic violence. And we have just incorporated an element of the family to be part of that unit. So, Miss Darampo, yes, you again. Yes. What I want to do this morning is to, and oftentimes we point fingers, we don't look at ourselves. And we come and we speak, and I honestly don't like it, but I believe we should not give up in trying to provide the information out there. Now, there is something happening as it relates to sexual offenses, especially. I'm deeply troubled. It can be one case or two cases by any incident of sexual connection, especially with a minor, unlawful, conduct. And we have a situation where an obligation is placed on a number of people to do certain things. And can you just take us, and we will look specifically Section 41A and Section 41B. We may want to look at 31 at 30 or 31C if we have time. But let's start there, and to give us an appreciation as to our requirements and how serious that Sexual Offences Act is.
Yes, the Sexual Offences Act has mandatory reporting requirements also. And there is also criminal liability placed on someone who does not report. So the people that fall under the umbrella of mandatory reporting in these matters is obviously the parent or guardian, someone who has actual custody, charge or control of a minor, has temporary custody, care, charge or control of a minor for a special purpose as his attendant, employer or teacher, or in other capacity, or is a medical practitioner or registered nurse or midwife and has performed a medical examination in respect of a minor. So these people are mandated by law.
Sorry, I wanted to read what the section says. Basically, it says shall. So
Shall,
okay,
yes,
so
which means that
yeah.
you don't have an option.
Right.
As long as you suspect or you note that a child may have been sexually abused, an offense has been committed under the Sexual Offences Act, you have to report to the police.
I would like you to because it's a very simple section. There's nothing to try to interpret. So I would like you to just read out the section what it says from.
Section 31A of the Sexual Offences Act of the Commonwealth of Dominica states, any person who is the parent or guardian of a minor, has the actual custody, charge or control of a minor, has the temporary custody, care, charge or control of a minor for a special purpose as his attendant, employer or teacher, or in any other capacity, or is a medical practitioner or a registered nurse or a midwife and has performed a medical examination in respect of a minor, and who has reasonable grounds for believing that an offense under this act has been committed in respect of that minor, shall report the grounds for his or her belief to a police officer as soon as reasonably practicable. Any person who without reasonable excuse fails to comply with the requirements of subsection 1 is guilty of an offense and liable on summary conviction to a fine of $30,000 and to imprisonment for a term of 5 years. And subsection 3, no report made to a police officer under the provisions of subsection 1 shall, if such report was made in good faith for the purpose of complying with those provisions, subject the person who made the report to any action, liability, claim or demand whatsoever. So this is the actual section coming from the Sexual Offences Act pertaining to mandatory reporting of suspected abuse of minors. And what is interesting is that the act is so strict, the law is so strict, that the offense of not reporting in the Commonwealth of Dominica is a serious offense. You have 5 years imprisonment, a term of 5 years imprisonment, or a fine of up to $30,000. So this in itself explains the seriousness of reporting when you are placed in a certain position with a child.
Yes, and we got. I think I kind of like that section because the reason why I like it, I never heard anybody being charged for that, and I've heard and we live in a culture where we point. The role of the government, the role of the minister, is policy oriented, and provide resources and to give approval in certain instances. But it's not for the minister to go on apprehend people. You understand? So
that is the job of the police, Mr. Minister.
And yeah, so I'm saying, and you're the prosecutor also. We'll get to that just now. We have gotten to a stage, and I'm saying that with no reservation, where we provide the education, where people with those responsibilities and who know of the violation of a minor and who is failing to report, people need to be charged and brought before the court.
I wholly agree.
And I'm saying that with no degree of reservation, it is time for that to stop. And so this culture of citywide, and this culture of absolute pretense,
cover up culture,
pretense and cover up, they are not helping the most vulnerable, the innocent, and stop holding politicians responsible for it. Politicians have to take the blows, have to be held responsible, especially those in offices. But at the same time, all of us have to appreciate our role in providing care and protection for the most vulnerable in our mix. Yes.
And I note, as Mrs. Kofi Kazimi indicated, there are channels to which reports can be made in respect of the care and protection of minors. Also, the Sexual Offences Act relates to the individual having to report to the police. I note that for certain matters, I mean, when it's on social media, you have people making certain statements, certain allegations. They know of this case, they know of that case. But how many of them come to go to the social services department? How many of them make a report at the local police station?
Well, I want to respond to that. I'm trying to remove myself as a minister for legal affairs, so to speak, and just apply common sense. But we have electronic laws in the country, both civil and criminal. And anything transmitted on social media from anything can be admissible in court. So if somebody comes on a social media platform and say that I'm aware of something happening, that person has exposed his or herself to legal jeopardy. So I think it's utilizing, everything that you have, and to make a statement and to make examples out of people who are worthless. And that's all I want to say on that.
Yes, and I believe our society too has to understand that we are not doing it for the likes. We're doing it as it's in respect of the law, and it's our civic duty to protect our communities, to protect Dominica, to protect the children. So it's not obviously in the course of doing something, you will gain enemies, but you are doing it for the betterment of your country. It's not being done for likes.
Well,
I like very much what Minister said.
I like that part is not being done for likes, and I want to embrace that.
I really like what Minister
Yes, Miss
said.
Coffee. Go ahead, Miss
I
Coffee.
really like what you said, Honorable Minister, as you touched a bit on social media, and I think it's an issue that we must address, because the tendency to place allegations involving children on social media is not making a formal report. And if you genuinely believe that a child is harmed, report it to the appropriate authorities. Posting the child's circumstance publicly can further traumatize the child. It can compromise confidentiality. It can expose the child's identity. It definitely can interfere with investigations. And it can create information that may follow the child for years. And children deserve dignity even when adults are angry. So protect the child first, report responsibly, and allow the appropriate agencies to investigate. That is what I would really push as it relates to social media and persons just posting frivolously because they are angry or because they are responding to a situation, an unfortunate situation which has occurred.
Essentially, they are part of the problem. That's what you're saying, eh? And that has to be amplified out there. Now we're going to come back to Miss Coffee in a while. We don't have much time remaining because, as I said, it's an abbreviated segment program. And normally we meet on a Thursday night for almost 2 hours. People are used to that on Thursday night, but sometimes you have to be creative. And so I think, Miss Coffee, if we now go back to you. Yes, you have spoken about people's obligation. You have spoken about your core function and that of your department and the support you give to the minister, and etc. But in the event that a child or somebody, or a battered woman or somebody, can be a man too, they're in a minority, but the law is gender neutral. If something happens to a child, or something happens to a battered woman, well, a wife or husband, or a significant other of either sex or gender to be. What system do you have in place? Firstly, from a legal standpoint, and secondly, in terms of a place of safety or foster home for the meantime, do you have in place? Do you want to speak to that?
Okay. When social services receive a report, there's a professional process. The Act specifically requires the director to undertake an initial investigation and an assessment. And when it appears that a child may be in need of care and protection, when assistance is requested, or when a report is received, right? This is the mandate stipulated by the Act. So this assessment now may involve speaking with the child, speaking with parents or caregivers, conducting home visits, consulting with schools, healthcare professionals, community members, examining the relevant records. Sometimes we have to do the medical records as well as school records, considering the child's physical, psychological, and social circumstances. The officer, therefore, following this assessment, the response may range from either no further action to additional investigation required, to family support or services, to development of a care plan, or to a court intervention, which would be, therefore, where necessary, the removal of a child. And so basically, the act in itself emphasizes that the removal of a child from his or her parent should occur only where it is necessary to protect the child. So in these situations where we really have to remove the child from the home, we have alternative placements, such as, like you highlighted, foster care placement, which oftentimes is supposed to be a short-term placement with intention for family reunification, but sometimes it ends up as being long-term placement. We have foster care parents who have children for 17, 15, 16 years. We also explore kinship care placement, whereby another family member, oftentimes that's the first option, where a family member who, if deemed fit, would assume responsibility for guardianship of that child. And a last case scenario is institutional care, which we know currently we have one government-owned institutional care facility, which is Chances, and then there is another, Operation Youth Gate, which receives a subvention from the government. So these are our options as it relates to placement, alternative placement, if removal has to take place. In the event that removal is not necessary, the department works with the family, be it through providing counseling or psychosocial support, providing financial assistance if it's an issue of lack of provision of basic needs, providing education regarding supervision and protection of the children based on the need of the family. So it's not a set in stone response. It's based on the cases, based on the results of the assessment and the investigation conducted, the intervention plan is followed through based on that. In situations, there are situations where emergency removal must take place, which I think Section 25 speaks specifically to the removal of children in cases of emergency, which basically gives the director the mandate to go in with the assistance of the police to remove the child and place the child in one of the areas highlighted previously, and then after that make an application to the court to have a formal order be made. Oftentimes in that case we'll have an emergency placement order made, and in some situations we can still apply for a care order in the guardianship of some responsible adult. So that is generally the process upon receiving a report and execution of duties until the child is safe.
Okay, I like the way I like the way you actually taking care of your business there, and very much comfortable, almost in your comfort zone, and so it speaks to your passion and commitment to a task that you are actually charged with, and I want to commend you for that. And so I wish you well. And as you made reference to the formal foster homes, etc., you made reference to Chances, but of course you have plans to actually improve on that formal capacity to actually, in cases where you have to move the child from a foster home into something that is at least more long term or something like that.
Yes, that is correct.
Okay.
And ultimately, the ideal would be a family member or reunification with parents and so on, because the bonds that have been created from inception, irrespective of the level of trauma which may have been endured, these bonds are almost irreplaceable. So, but yeah, like you rightly said, short-term placement with the ultimate goal of long-term placement, which ideally would be family.
Okay, thank you very much. As well, let's go back, because what we try to do on that program is to provide as much information as possible to the public, and as more or less, and then we do not really take too many calls. Although the last program I had with the Minister for Energy, we just went beyond our time, and a number of calls came in. But this morning we don't have much time, so I want to allow you just to explain, and we'll be back on a Thursday night to go beyond what we have just spoken of tonight, to this morning. But Miss Diram, I want to go back to you on something that is, again, I am very much concerned about. Section 51B, and it speaks to obstructing prosecution in cases where, and I know right now you may have a few cases, one or two cases, where you have minors actually allegedly, so to speak, but I would hate to believe that the police, and sometimes when the matter goes before the DCP, the DPP would proceed to prefer charges against somebody if there's not a reasonable grounds for believing that that person is culpable. You do get my point I'm saying? So when you have, and to arrest somebody, so to speak, and so when you have situations where that has been done, your case file is completed, statements are collected, and you're about to have the matter brought before the court, then you have situation where parents or guardians, when they make the complot with their
wajma.
Complot is a complot too. Complot wajma, yeah, wajma. I call it complot because you're involved in something almost like a conspiracy, so to speak. Because you guys don't want each other to testify. I give you something and make sure each other doesn't testify. Now we have a caller. Let us just see if we can take a call. Hi, good morning.
Hello, is this DBS?
Yeah, this is DBS. Let's do that quickly, please. You're live.
Okay, nice. Okay, that's not a problem.
Mm.
I've been listening to the radio, and what I've realized is, based on what Mr. Blackmoore is saying, isn't he the same one who bailed a doctor that shot a young lady in the starting of this year?
Who's that?
Where was her assistance?
Who's that? Who bailed who? That's not true. That's that's not true at all.
The doctor that shot the young lady in the starting of the year, Dr. Thomas.
No, we're not there to convict anyone. But I want to say to you that the DPP actually office opposed to bail. So get your facts straight. Okay, sir?
Excuse me?
The DPP office opposed bail. All right?
Yeah, but you did not do enough.
But I'm not sure about that. The court makes a deliberation, and we're not there to actually. So, I have strong views about that matter myself, maybe just like you. But the objective.
Okay, but there was no counseling. There was nothing to assist of the trauma after that incident happened. I'm
saying to you, the intention of this program this morning is not to litigate a matter that is live before the court. And so I don't want to get myself involved in any pre-trial publication or transmission over the air on the matter is before the court. So I appreciate your call, and I'm happy for your concern, but we have to respect the rule of law. We have to respect because...
Okay, I understand.
All right? Okay?
Have a good day, and God be with you all.
You too, man. So, one love. All right. Yes. Let's continue. So we're looking at Section 41B, where in certain instances, guardians, parents,
Section 31B speaks to obstructing prosecution. It makes it a criminal offense. And Section 31B reads, where a person prevents a minor from A, giving a statement to the police, or B, testifying in proceedings relating to a sexual offense, that person is guilty of an offense and liable on conviction to a fine of $50,000 and to imprisonment for a term of 5 years. So we have where someone is preventing a child from giving evidence. We have a charge before the court, and therefore in some way the child is being prevented from giving evidence in the matter. We can charge for obstruction of prosecution. We can charge that person for obstruction of prosecution. Now, what is interesting is that there is another serious offense based on the aggravating matters of the case that the state can charge that individual with. It falls on all fours with perverting the course of justice also, which is a criminal offense that can be found under the Criminal Law and Procedure Act. And the sentence for perverting the course of justice is 14 years imprisonment. So besides we charging for obstruction of prosecution under the Sexual Offences Act, the police also have the charge of perverting the course of justice available to them.
Yeah.
We have in the past, Mr. Blackmoore, we have charged someone for obstructing prosecution in a sexual matter. It's not a live matter anymore. I prosecuted that person about 7 years ago, where on the day before the trial, the child was brought out of the jurisdiction.
Not aware, but the fact of the matter is we have systems in place and we have agreements.
So we have employed that particular section of law in the past.
I'm happy to hear that, because I wanted us to actually give some currency to that section here this morning. And the fact is, I know of an instance that is before you, maybe before you now, where a parent is writing and saying that a child does not want to. Now the law, from my understanding of it, it may have to go beyond just the letter, writing a letter. If the matter comes out for a live hearing, and that person proceeds to prevent the child from testifying, then that offense, all the elements for that offense would have been met if the person proceeds to prevent or to take a child away, do something and lock her in a room, bring her and hide her from the police or hide her from you.
And also the law, actually, the accused would fall under the umbrella of that section, because we spoke earlier about the cover-up, the wajma. We usually have sometimes where we know that the accused may have approached the family of the child and something is going on. We may not have evidence, but the circumstantial evidence that is being brought out that something is not right. As prosecutors, we pick up on that. And the accused can fall under that section, and he can fall under the section of perverting the course of justice.
Okay, we don't have much time. We have about 2 more minutes remaining, and I wanted to speak to something, because sometimes our culture actually is defined by a certain element of birth from our days of parents, the days of making calypsos on the farm, etc., on the estate. It's a birth-oriented kind of culture, so to speak. But sometimes Hurricane has a song, "Miami Birth, you lay birth la." Now the thing is that I was listening to something, and an advocate for child's care and protection, who sometimes out of emotion do not actually read or have an appreciation for the actual language within the Sexual Offences Act from a holistic standpoint. They're making some reference as to say sometimes somebody is raped, a child or an adult, and the person's sexual habits or activities have to be revealed in the court, etc. etc. Some people don't want to go for that. But doesn't Section 30 actually prohibits that, and from because it's just somebody's past sexual activity has nothing to do with the current charge or the current accused. So do you want to maybe speak about that quickly?
Section 30 prevents sexual history from being admitted in court per se. The only way it can be done is where there is an application from the defense and they give some circumstances where it is necessary in proving the defense.
But Mark, in the absence of a jury.
It's done in the absence of the jury.
Okay,
yes.
fine. Okay.
It's done via voir dire.
Okay, fine.
But in my career practicing, I've done hundreds of sexual matters, and this has been raising about 6 or 7 of them, and the court never gave permission to lead the evidence because it is not relevant and it's highly prejudicial to the prosecution's case all of the times. So section 30 subsection 1 says, in proceedings in respect of an offence under this act, evidence shall not be adduced by or on behalf of the accused concerning the sexual activity of the complainant with any person other than the accused unless the court, on an application made by or on behalf of the accused, in the absence of the jury, thinks such evidence is necessary for a fair trial of the accused. Subsection 2, save as provided in subsection 1, evidence of sexual reputation is not admissible for the purpose of challenging or supporting the credibility of the complainant. So you see the notion that goes around within the public domain that the child is promiscuous or the child have a man. That cannot be the reason for saying that you want to raise sexual history in a sexual matter concerning a child.
And the reason why I'm saying that, the government has looked at all the elements to close the loopholes in the law. They understand to ensure that level of protection is provided for, especially for a minor, and even an adult who is violated, so to speak. The last point I'd like to touch on quickly, because I also heard that in the BEF. You understand? That sometimes, a minor has been violated, and the minor is prevented from testifying, and there's nothing in law. Do you want to look specifically, I think, Section 41C, in the circumstances where the court is satisfied that child is prevented from testifying, but that child's statement is in a written form, and so do you want to speak on it, and the court is satisfied that actually can be that statement of the child can be dictated in the court? And do you want to speak to that?
Yes, 31C allows for, in sexual matters, for the statement of the child to be admitted into evidence where the child is unable to give evidence, or where the child for some reason is being prevented from giving evidence. Unable to give evidence, I've seen that children sometimes they are so emotional. They have some psychiatric and psychological issues and are unable to give evidence. The court is permitted to allow the prosecution to present that child's statement to the court in the trial of the matter. So the Sexual Offences Act has gone a long way. This was not there in the 1998 Sexual Offences Act. This section was not there. For every sexual matter, we had to bring the witness to court. But right now, we have the ability to bring a witness statement to court, providing that it is done in a particular format as mandated by the law. Also, listeners, the Section 33 of the Sexual Offences Act also allows us to have video recorded evidence. So during investigations, the police can take a video of the child giving his or her statement, and that can be admitted into court. I love video evidence because you get to see the demeanor of the child, and that is something that the jury considers when they're giving a verdict. The demeanor, the way the child speaks to the incident, the way the child describes certain things, the youth of the child, the innocence of the child. So I think that the Sexual Offences Act, the sections, they have covered all bases in respect of presenting evidence before the court in support of a charge.
Excellent. Okay, so yes, we just in overtime there, so I'm going to ask that you give a closing remarks before we get kicked out of DBS Radio, although I'm one of them. Yes, let's go with Miss Coffee. It's so nice having you. Thank you very much, Mrs. Kazimi, for being with us, and even if you're outside of Dominica, I want to commend you for that. Your closing remarks, please.
Okay, my closing remarks. My appeal today is not simply as the Director of Social Services, is as somebody who is asking us to think seriously about the kind of society that we want for our children. The Children Care and Adoption Act gives a strong legal framework, but a law alone cannot protect a child. It requires our conscience, our courage, and of course, our collective responsibility. Thank you.
Yeah, I love that. I love that concise close to your contribution here this morning. May the good Lord continue to bless you. And tell your father good morning for me. All right?
Thank you.
He took care of me when I came into CID as a recruit and stayed until he left. Nice man, one of Mr. Coffee. Big, strong man, a very nice guy. Now, Miss Darampo. No, I have it right? It's Miss, right?
Miss.
Yeah, thank you very much. Yeah. Your closing remarks, please.
Yes, I will start with the simple phrase, the children are our future. Protect them, care for them. Where they're being abused, be it deprived of food, sexual abuse, they're not attending school. Teachers know that a child is not attending school. Report. The protocols exist, the services exist for these matters to be dealt with. I mean, Parliament has passed legislation. Parliament has put in the Director of Social Services. Give her some work to do. Also give me some work to do. Pursue the sexual matters before the court. Be vigilant in pursuing these matters. Do not accept my child is 16 now. I don't want her to go and give evidence in court. No, the children are our future. Let them deal with the issues that face them. Where they are violated, let them deal with it through the laws of the Commonwealth of Dominica. The laws were put in place for a reason, and so we can give them the necessary support they need, the necessary psychological support, so they can continue along their way and have a very bright future.
Okay, I'm happy you're saying that, because at a subsequent program, God willing, we have not even spoken about the Children and Young Offenders Act, because there's an excess,
Yes.
And of course, children are not allowed to beg on the street. Children should be in school and to sell alcohol. All this kind of stuff. Miss Coffee, Mrs. Kazimi. We speak about these things and look at ourselves and the issue of enforcement of the laws. And we have to be more proactive, but we also have to enforce the laws that we have on the books. We have to enforce the laws. So there has to be, like a rebirth, on the part of all of us, to look within ourselves and to do what we are charged to do, and to pursue our task with that level of gravitas, and to hold adults, especially, who violate minors, and even adults, hold them accountable, and let them be where they're supposed to be, in safekeeping. But that safekeeping should not be a foster home. Okay? Thank you very much, and thank you, DBS Radio, for having us here this morning, and thank you to our wonderful listeners. And don't forget, DBS Radio is absolutely the best station in the Caribbean, best in Radio Land.